waiting on for the verdict right now, and we're going to learn the fate then of Nima Momeni. He, as you know, has been on trial for the killing of Cash App founder Bob Lee.
Yeah, the jury announced late yesterday it had reached a decision, and this morning we expect that decision to be read in the courtroom in less than a half hour. KRON 4's Will Tran live in front of the courthouse now. Will?
James, we're about, 27 minutes away from the verdict being read. We might as well set a countdown clock. We do know that jurors, they are inside the courtroom as we speak because we were told not to video them as they walk in, and we shall see same time as you. So when it comes down, we'll let you know in real time exactly what the verdict is. It could be first-degree murder, second-degree, or it could be not guilty. So everybody is on pins and needles. There are so many media members inside that I'm sure many will not be allowed to go inside the courtroom. I only mention that is because this is an extremely high-profile case that dates back to April 4th of 2023 when Bob Lee was stabbed on the streets of San Francisco in the overnight hours by someone who he thought was a friend, Nina Momeni. Now, that was around 2 o'clock in the morning. Momeni, he admits that he stabbed Bob Lee, but he claims it was self-defense, and he hopes that jurors believe that, and if so, he possibly could get manslaughter, which reduces his time in prison, or best case scenario for him, he could be found not guilty. Now, prosecutors say it just simply does not make sense that they claim Momeni was an overprotective big brother who did not like what was going on between Lee and his younger sister, and that he planned this all, and he stabbed Bob Lee, leaving him to stagger through the streets of San Francisco to ultimately die. We will let you know, and we will be pushing it on our website as well. Lots at stake, guys, and you guys have been covering this as long as I have. It's not Momeni that's the only one on trial. San Francisco itself is on trial because back then, and I'm sure even now, nationally, people point to San Francisco as a lawless town that is soft on crime. Brooke Jenkins, from time to time, she popped into the courtroom as well to listen to the proceedings, and I have no doubt she will be there when the verdict is read. Back to you.
All right, thanks a lot. Now, to talk more about the ins and outs of this high-profile murder case, we have a civil rights attorney, Adante Pointer.
Yeah, joining us this morning from the East Coast. We really appreciate you joining us on a day that we've been anticipating. It's been a while. The jury's been deliberating for quite a little bit. What are your thoughts this morning as we're less than a half hour now from the reading of that verdict?
I, like many of your viewers, are, anticipating what the jury came up with, what decisions did they make, if any, and how this will all play out. This certainly, we've been all at the edge of our seats as it relates to this case. From the very onset, it's gripped the nation's attention. It's been very much covered. It's a high visibility case. And frankly, there's a lot at stake. Justice on both sides are at stake in this situation.
Yeah, so what are the different, only because you said, if any, what are the different choices that could come in as you see it, having heard the case, the first degree versus manslaughter versus not guilty? Because he said he did stab,
right.
There was a stabbing.
Right, and yes, so the defendant actually in this case took the stand. That doesn't happen in every case. It happened here. And so the question is, how did the jury take, and do they give credibility to his justification, to the way his story played out as relates to being forced to defend himself, or do they believe the prosecution, which is that this was something that was intentional, this was something that was done with a plan, and essentially this killing was a result of retaliation, if you will, for what he believed the way that the victim treated his sister. So that's what's at stake, and the way in which the jury decides to take the different competing stories is how it will play out. A conviction could be in the awful, or it could be an acquittal.
So, but if the decision is, he was forced to defend himself, then would that still be, he would serve prison time for that?
No, if the jury comes out and believes that essentially this killing, this stabbing was a result of self-defense, then he should be walking out of that courtroom today a free man. If the jury believes otherwise, in that, yes, this was done, but it was done in the heat of a passion, this was done because drugs and so on and so forth were involved, and that this killing was not legally justified, then we'll not only see a conviction, You'll also have to go to the next phase, which would be sentencing. And of course, there'll be a long amount of appeals of if a conviction and a sentence were to come out. So this may not be the end today. This just may be the start of a new chapter in this book.
Leaning on your experience with cases like this, the fact that the jury took the number of days it took to find a decision here, to finally agree, does that tend to lean you one way or the other in terms of what they might have come to? I'm curious, justified self-defense, the jury deliberated for a long time. The fact that they deliberated that long, does that kind of take that off the table? Wouldn't that have been something they decided much quicker?
Well, you know, you would tend to think that if they were going to come down one way or another, that decision would have been reached quickly. However, there was a lot of different material and information and evidence presented in this case. It's a high visibility case, and it may just mean that the jury took their time to review the case. I know they had questions along the way. However, you tend to believe that if the jury takes more time, that it's going to tend to lean towards a verdict or a decision that favors the defense versus the prosecution. So I'm sure that the prosecution is pretty nervous, waiting like the defense attorneys are as well for the jury verdict. But you would tend to think more time inures to the defendant's benefit. So I'm sure the defense attorneys are over there. They like the fact that they didn't come back with a quick verdict, because that tends to mean a prosecution verdict and a conviction.
But when in doubt, because the standard is, I mean, when in doubt, we talk about it, reasonable doubt. When in doubt, you favor the story of the defendant, right? Because that's innocent until proven guilty. So I get why that would take more time. Okay, and then also, then there can be technicalities, and I don't know if there are any that you already saw popping up as an attorney where, like you said, could be the beginning of yet another kind of appeals and that sort of thing.
Well, sure. You know, attorneys are always going to spar over what evidence should be admitted, what evidence the jury should be able to hear or review, or even take back into the jury deliberation room, or comments that are made during the course of the jury, be it by a witness, someone in the gallery, which we know we had outbursts here. And so, you know, there are any number of reasons for appeals for attorneys who are looking to appeal or overturn a conviction. So, and the defendant here has well-financed and, you know, skilled attorneys on both sides of the case, frankly. So an appeal is likely no matter which way it comes out. However, if it's an acquittal, of course, the defendant has no reason to appeal, and it'd be on the prosecution to show that there was some sort of misconduct, which it's a much harder hill to climb than it is for the defendant as it relates to appealing a jury verdict.
Okay.
Can you give us any insight, as we're almost out of time here, but any insight as to how juries process a case like this? What do you suppose transpired in there? What were the back and forths of this case that they might have been hashing out?
Well, yeah, in my experience, you know, I was a criminal defense attorney for well over a decade, doing murder cases myself. I know that juries sometimes, you know, fixate, or a juror will fixate on a particular item of evidence or a particular witness testimony that comes in. And it's almost like, you know, trying to read the tea leaves, if you will. Sometimes you're thinking, an attorney will think that a particular item of evidence should be very persuasive, only to find out that it was something that you didn't really pay much attention to or much consideration for that actually swayed a jury. So, you know, it's all up in the air, but I'm sure the defendant's testimony is something that's weighing heavily as it relates to his credibility, but also the physical evidence here and the way in which it was processed, which we've seen shades of that a la O.J. Simpson, in the way in which police tech handled the items of evidence and whether or not the way it was handled was appropriate.
Okay.
The technicalities you were talking about.
Yeah, all right. Well, we'll see what happens, and we'll be standing by. Thank you so much.
Thanks for having me. Take care.
And we'll take a quick break. Be right back.